First, she lost the job, then the car, then the license that would have let her go find another job. Then a courtroom took the last thing left, her freedom, over a stack of traffic tickets she could not pay. Not for a crime, not for refusing anyone, for being broke. Ask it about yourself. Can they lock you inside a cell for the one reason that you do not have the money? This is Montgomery, Alabama, and a small debt that turned into a sentence. The Supreme Court of the United States answered this question a long time ago, in 1983, and the answer was no. A state cannot put you in jail for the one reason that you are too poor to pay what you owe it. This is Montgomery, 3 decades later, doing it anyway. Harriet Cleveland lives in Montgomery. She gets traffic tickets, the ordinary kind, the kind almost everyone watching this has gotten at least once. What she cannot do is pay them all at the same time. So the fines sit. And in Alabama, a fine that sits does not stay the same size. It grows. Her license is suspended for the tickets she has not paid. But a life still has to be lived, so she keeps driving to look for work, to reach a store, to get anywhere at all. And every time she has stopped driving on that suspended license, there is another citation, another fee laid on top of the pile. She is out of work. She cannot afford car insurance. The bus does not run out to where the jobs are. The nearest store is a long walk in the Alabama heat. So she keeps driving because in a city built for cars, not driving is its own quiet sentence. Every fix costs more than the thing it fixed. Then the arithmetic ends the only way this arithmetic can. A judge in Montgomery signs an order. Pay $1,554 or serve 31 days in jail. And the number is not the cruelest thing on the page. The order was entered without anyone asking the question that was supposed to come before it. Could she pay? There was no hearing on what she had. No finding about the state of her wallet. There was a sum and a cell waiting if the sum went unmet. She could not meet it. So Harriet Cleveland was booked into the county jail, and the door closed on a woman whose only proven offense that day was that she was poor. It should not have been able to happen, not in a country whose highest court had forbidden it decades earlier. But in Montgomery, the money had somewhere to go. Cleveland was not simply fined and sent home to pay. She was placed on probation, and her probation was not run by the county. It was run by a private company in business to make a profit. Its name was Judicial Correction Services. The model has a name of its own. It is called offender-funded probation, and the premise is exactly as blunt as it sounds. The person being punished is made to pay for the machinery of their own punishment. The court hands the case to the company. The company collects the debt and skims a fee for the service of collecting it. Cleveland was ordered to pay $200 a month. Of that, $240 never touched her actual fines. Every month it went to the company as its charge for supervising her. The more she failed to pay, the more the company earned. Her ruin was its revenue. And here is where the constitutional rule quietly bent. The single question the Supreme Court said must be answered before anyone is jailed, the question of whether a person genuinely cannot pay, was in practice handed to the people whose paychecks depended on the answer being no. Human Rights Watch documented precisely that pattern, courts delegating the ability to pay decision to probation company employees, a conflict of interest wired straight into the design. And there was one more thing missing from these rooms. In the proceedings where the fines were tallied and the jail time was handed down, people in Cleveland's position were not told they had any right to a lawyer. So the one voice in the room that might have been trained to insist on the words the Constitution required, could she pay, was often the one voice that was never present. There was no one at the table whose whole job was to say those two words out loud and make the court stop and answer them. Cleveland was not an unlucky accident in this. She was exactly what the model was built to produce. By 2013, that one company was working in at least 100 Alabama courts, and roughly 38,000 people were on that company's rolls across 4 states. And a judge saw it plainly. In 2012, an Alabama circuit judge named Hub Harrington moved to stop the company's practices in a town called Harpersville, and he did not reach for gentle language when he described what he had found. He called it a judicially sanctioned extortion racket. That is a judge speaking about a court. One judge in one hearing put the word extortion into the permanent record. The practice went on in the towns next door. This returns us to the promise the country made, the one from 1983. It has a name, Bearden versus Georgia. The man in the case was named Bearden. He pleaded guilty to burglary and theft, and the court sentenced him to a $500 fine and $250 in restitution on a schedule. $100 the day of sentencing, another $100 the next day, and the remaining $550 within 4 months. He borrowed the money to make the first $200. Then he was laid off. He had a 9th grade education, he could not read, and with no work and no income, he could not pay the balance. Georgia revoked his probation and sent him to prison for the shortfall. His case climbed all the way to the Supreme Court, and in the spring of 1983, the court ruled in his favor. Justice Sandra Day O'Connor wrote the opinion. The rule she lays down is narrow, and the narrowness is the entire point. A court cannot revoke probation and jail a person for failing to pay a fine unless it first finds one of two things. Either the person willfully refused to pay when he actually had the money to do it, or he had not made a serious, honest effort to find the work or the loan that would have let him pay. And even where non-payment is not willful, the court still has to ask whether some punishment short of a cell would serve. O'Connor writes that when a probationer has made all reasonable efforts and still cannot pay through no fault of his own, it is fundamentally unfair to revoke his probation automatically, without even considering whether an adequate alternative to prison exists. The Constitution she reaches for is the 14th Amendment, where the court says the principles of due process and equal protection converge. And Bearden did not arrive out of nowhere. 13 years earlier, the court had already said a state cannot hold a person in jail past the longest sentence the law allowed for his crime just because he was too poor to pay a fine. 2 years after that, it said a state cannot take a fine and simply swap it for jail time for one reason alone, that the defendant is broke and cannot pay it all at once. Bearden was the capstone on that line. But Bearden did not abolish fines. It did not say the state can never make you pay a dime. Courts can still impose fines, fees, and restitution. They can still punish a person who has the money and simply refuses to hand it over. What the Constitution forbids is smaller and more exact than that, and the exactness matters. Jailing a person for the sole reason that they cannot pay without ever stopping to ask whether they could. And that is the line the order against Harriet Cleveland walked straight across, because no one asked. And it would be natural to picture the Supreme Court riding back in to rescue her, the way it rescued Bearden. It did not. Cleveland's case never reached the Supreme Court at all. Her freedom did not come from 9 justices in Washington. It came from an ordinary lawsuit in a lower court and from a settlement announced in late 2014 in the case that carried her name. The terms of that settlement read like the rule from 1983 being written out a second time, by hand, because the first time had not been enough. No person shall be incarcerated for their inability to pay fines and fees. Ability to pay must be determined on the record before anyone is jailed. Under the settlement summary, the extra fees layered onto payment plans were to be reduced, and the city of Montgomery agreed to end its contract with the private probation company. A settlement in the year 2014 had to make a city promise to stop doing the precise thing the Supreme Court had declared unconstitutional in 1983. The law had not changed. It had been on Harriet Cleveland's side the whole time, and what failed for 3 decades running was the simple business of enforcing it. And the machine did not vanish quietly either. In March of 2015, the Southern Poverty Law Center sued the probation company under a federal racketeering statute. By the end of that year, the company announced it was closing all of its Alabama operations as one municipality after another cut ties. Go back to the number, $1,554, or 31 days. For anyone with the money, it was not really a choice at all. You write the check, you go home, you never think about it again. The jail sentence on that page existed only for the people who could not reach into a wallet and make it disappear. Which means those 31 days were only ever a punishment for what Harriet Cleveland did not have. The same order on the same page meant nothing more than a receipt for a person with money and a locked door for a person without it. And there was a cruelty folded into the very shape of it. The license they suspended for unpaid tickets was the same license she needed to earn the money those tickets demanded. Take away the driving, and the work goes with it. And once the work is gone, the debt has nowhere left to climb but up. The punishment for owing money was to be made less and less able to earn it. The Constitution had already answered her, and answered her clearly. The words existed. A book on a shelf in that very courthouse held them. On paper, the right was hers in 1983. In that courtroom, on that morning, no one reached for it. It is one thing for the Supreme Court to write that you cannot be jailed for being poor. It is another thing for that sentence to be honored by a particular judge in a particular county on the morning your name is called. The Constitution was on Harriet Cleveland's side the whole time. It simply never walked into the room where she was standing. So, the question we started with, can they lock you in a cell for being poor and nothing more? The Supreme Court's answer since 1983 is no, and that answer still stands. But an answer settled in a book in Washington is not the same as an answer obeyed in a courthouse 1,000 miles away. The rule held. What kept failing, county after county, was the simple act of following it. If you assumed a rule the Supreme Court settled more than 40 years ago was simply being followed everywhere, and one woman's cell in Montgomery just changed that assumption, that is worth a like. It tells the channel to keep checking whether the rest of the country's courtrooms are keeping the promise this one broke.